Good morning. Thank you very much for joining us today for our Q4 quarterly legal update for the residential lettings sector, covering everything you need to know and everything you probably want to know about legal and compliance updates. We've got a really varied menu of topics for you today, and thank you to everybody who submitted questions in advance. So our quarterly legal update, and thank you very much to the lovely people at JMW Solicitors for releasing David into our daycare for an hour to go through today.
The usual saves them having to provide other carers.
The usual disclaimer: so everything today is for general information purposes only. It shouldn't be taken as and must not be construed as legal advice or official guidance. But if you would like legal advice, please do contact David at the end of today's webinar, and you'll get all of his contact details. I'm sure he'd be delighted to assist if there are specific legal questions you would like him to address. And over to you, David. So would you mind doing a quick introduction for the audience?
Oh, wow. Yeah, that's my usual introduction. I am a partner at JMW Solicitors in London. I'm in the office today as well, which is particularly nice place to be in exciting sunny London. I know things apparently about residential landlord and tenant law, as I always say. How much I know is a matter of some debate and dispute.
Well, at the end of today's webinar, everyone will be asked to provide feedback. So on a scale of 1 to 10, how useful did you feel? We'll use that as a proxy of their views on your knowledge and expertise.
How much did David know from 1 to 10?
Exactly right.
1, very little. 10, so much I was shocked.
And with this, we're going to crack into our first topic. So a lot has happened. So it's probably worth starting with government updates, MHCLG as was. What is it now? What's happening? What insights can you bring?
I mean, well, as we know, there is no MHCLG. I've seen a press release saying that, as you know, it's the Department of Levelling Up Housing and Communities. The last press release I saw from them said that they haven't officially decided that we can use the acronym DLUHC, and they will get back to us later to let us know what the acronym actually is. But I suppose we're calling it DLUHC. There is, of course, a new and improved, I suppose, Secretary of State, Michael Gove. And I should probably just highlight the sad and untimely death of James Brokenshire this week as a former Secretary of State for the housing under Theresa May's government, which I thought was a shame. Obviously, you can take your own views on government, but he was certainly one of the more thoughtful housing ministers I found myself working with. It was there's a new Secretary of State. Michael Gove is in the Govester, if you like your dead ringers. It has arrived. The key question, I suppose, on everyone's mind is whether this signals a change of tack. Michael Gove, in my view, has historically been more of a house buildy guy. That's not to say that Robert Jenrick wasn't a bit of a house buildy guy, to be fair, rather than a renty guy, but what the hell. Michael Gove has been much more a house buildy guy. Obviously, you can choose to read a lot into the addition of levelling up at the top of the name and housing moving down, and therefore is housing deprioritised. I mean, I would point out that Eddie Hughes remains the housing minister, and so there is a degree of continuity there, and he has been at pains to say that the government is still committed to reform in the rental sector. So I think it remains to be seen. I think it was particularly notable at the party conference this week in a fringe event that Eddie Hughes intimated that the white paper is now no longer being delivered in October, which was fairly obvious, frankly. And that's because of extended consultations. And I suspect now that probably means it'll appear in the new year, because you don't tend to get a lot of stuff appearing around Christmas in the end. It all tends to get pushed off. The question is, of course, is that a lack of interest, or is that just more consultation, which will lead to a better white paper? And of course, the other point to make, of course, is that a white paper is all very well, but a white paper isn't actually an act of parliament, and there's quite a long way from a white paper to one or more bills actually getting passed through the House of Commons and the House of Lords and actually becoming law. So So I think a change of Secretary of State is from all purposes probably not great news, in that it definitely means that things will drop away that were priorities before, because different sectors have different priorities. The key question is whether renters reform is one of those. Obviously, some people will be opening the champagne if they think Section 21 is going to continue. Other people will be crying into their crying bitter tears into their cold tea. So it depends on your perspective. But in general terms, I think that it's unfortunate that yet again, housing and the MHCLG as was finds itself being this place where ministers pass through. We need to have much greater continuity. The Home Office doesn't have these number of changes. It's not arguably that much more important.
I'm going to put a slightly more positive spin on that, which is having a heavy hitter at the head of the department, and a heavy hitter with a reputation for implementing change may be positive, to be confirmed. And also the fact that the Renters Reform Bill white paper is still being discussed, and it hasn't been mothballed, but it has been delayed, I would take as a positive, assuming that the consultation results in a better paper, but we'll have to wait and see. And so moving on from politics, to the extent you can move on from politics because it underpins everything across the housing sector, moving on to legal updates. So possibly quick fire, depending on which of these topics we get drawn into and the feedback from the audience. What is the Economic Crime Anti-Money Laundering Levy, or ECL?
Right, so this won't apply to everyone. There's a consultation ongoing. As I'm sure everyone's aware, money laundering regulations apply to a state agency, and also, since the fifth money laundering directive, to high value lettings. Those are ones basically where the rent is over €10,000 a month, or expected to be over €10,000 a month for a significant part of the tenancy, which is off the top of my head about £8,700. But you can go and look it up. It varies on a day-to-day basis by a little bit, which is one of the problems, frankly. We're still waiting for the guidance on the fifth money laundering directive. It's been endlessly delayed. I will admit that some of that is my fault, but there we are. I can't say any more about that just now. I think it's kind of funny, actually, this guidance issue, because when it was first talked about, I jokingly said to the civil servants involved, "Oh, does that mean we'll get it before Christmas?" And they said, "Oh, we'll definitely have it before Christmas." And in my most recent meeting with them, I said, "Well, we get it before Christmas." And they said, "We'll see." So they're not even prepared to promise that they'll be out by the end of the year anymore. So we'll just have to see where it ends up. It's got to be signed off essentially by Treasury ministers. That's kind of where we are at the moment. But those things take time, especially when you change some of your Treasury ministers around. Although obviously the Chancellor has not changed, but junior Treasury ministers have, and they tend to be the ones who sign this stuff off. So alongside that, there are in fact two consultations ongoing on the fifth money laundering regulations in the UK. One is to make some changes to the whole thing, although they're quite complex and technical. I'm not going to go into those. The other is that the government wants to introduce what's called an economic crime levy, and that's to make people, and it's pretty big businesses. We're talking about business, I think, earning more than about 10 million a year. So for many of you, you'll be like, yeah, whatever. But it's to make businesses within the regulated sector who are larger pay a levy, amount unspecified, to help cover the costs of economic crime enforcement. Obviously, one of the problems with this is what enforcement and what we're getting for our money, which is kind of a slightly annoying aspect of it. There's not exactly a great groundswell of success that you can see that your money is going to get used for. But the rather more salient point is it's calculated based on revenue, and it's not revenue within the regulated sector, it's total UK revenue. So, for example, if you have an estate agency which makes £8 million, say, and a lettings agency which makes £5 million, but all of the lettings work is below the threshold for 5 MLD, then your revenue for the purposes of the economic crime levy is £13 million, and you are leviable across it, even though a huge chunk of your business falls outside the regulated sector. So the current consultation, one of the reasons I'm really saying agents should respond, the current consultation will penalize people in effect who are making quite a lot of their revenue outside the regulated sector, and will suck them into the levy and increase their levy payments. And it could be quite a lot of money.
And is this UK wide? Is it England only? So to what extent?
This is UK wide stuff.
Okay. One of the comments we previously had is, could you be a bit more specific about what you're talking about and where it applies? And I think when we come on to possession claims, we'll dig into that a little deeper. We've talked at length, and I think necessarily at length, about the changing right to rent checks, because there's been continuous changes around that, and about possession claims. But starting with right to rent checks, where are we now and what is changing?
Well, it's got a bit unclear. There's new guidance, and we talked previously about the new code of practice. I'm not going to belabor that again. And we've gone on about B5J SSK nationals until people just wanted to give up on this acronym stuff altogether. So the current position is that the government has again extended the COVID protocol for doing these checks online right through into next spring, March, I think it is off the top of my head. And there's a clear intimation that what they're intending to do by then is alter the regime sufficiently that the majority of checks will be done online, ideally by using their portal. I mean, some of this is based on the fact that actually the settled status stuff is not properly sorted out, and the portal's not working all that well in those cases. But there's a clear ambition to get the majority of these checks, where possible, into the government's portals. Obviously, that won't apply to UK and probably Irish nationals. They will be trad, let's see your passport. It's more about people who are more complex. And of course, the government doesn't have a choice, because the more complex they make it by signing more and more different trade deals and deals with people, the more they've got to do that. Because it was kind of easy before, when you just said, well, do you have an EU passport or don't you? But now, of course, you've got to start thinking about B5J SSK nationals and how they arrived in the country. And the government is desperate to go and sign deals with India. And there's already been a discussion. In fact, part of the India deal will be extension of student visa rights. So you start to make the whole thing incredibly complex. And it was always the case that the government was going to have to do something to cover this. Before you ask me, this is England only at the moment. Right to rent is not rolled out to Wales, Scotland, or Northern Ireland. Again, I think this is an interesting point, is part of the plan here to get this rolled out properly nationally. The Home Office has always been adamant that it was going to roll it out in Wales and Scotland. Wales has been pretty quiet on the topic. The SNP have been pretty consistently anti the whole thing. And of course, it's a bit of I mean, given the disagreement between the English and Scottish governments over our status with the EU, imposing further checks on EU nationals to allow them to rent property in Scotland is likely to be a bit of a red rag to a bull. But ultimately, the Home Office has got to either make this, it's either got to be the Home Office for the UK or not. I mean, the Home Office is supposed to represent the whole country and supposed to deal across the board with immigration. It's not supposed to be an England-only thing. So they do really need to assert their authority on this one eventually.
And I suspect we'll get a question for people who've not previously been on the webinars. B5JSSK, Big Five, Japan, Singapore, and South Korea.
There you are. You see, it's easy.
Hopefully that helps. And Big Five, sorry, could you?
Big Five is the UK, but you can discount them for this purpose. So it's only really four: US, Canada, New Zealand, Australia.
Perfect. Thank you very much.
The bigness of them is open to dispute, but that's it's a historic World War II era title. Whether you think New Zealand counts as a Big Five economy today is another matter. Or even the UK, come think of
it. And moving on then on to possession claims. So what is the update on possession claims?
So as I expect most people are aware, as of the 1st of this month, notice periods in assured short-hold tenancies jumped back to their pre-COVID stuff. So I'll summarize it quickly because I had to go and look it up myself because I'd forgotten. So Section 21 notices are back to 2 months in the vast majority of cases, unless you have to give longer notice because of a period of the tenancy being longer, which is a more complex question. Section 8 notices are 2 weeks for most stuff. So rent arrears, breach of contract, that kind of thing. 2 months for things that are not really the tenant's fault. So ground 1 where the landlord just wants the property back, ground 6 where the landlord wants to redevelop. And then for antisocial behaviour, slightly different. No notice for ground 14, 1 month for ground 7 big A. So we're sort of back to the way we were. But just to make things more fun, there are also new Section 8 and 21 notices as of the 1st of the month, which are considerably different. If you're using the old notices, they really should not be used. They are defective. Make sure you're using the latest notices from the MHCLG website. You really must use the new ones. They are dramatically shorter. To an extreme degree. And the reason for that is all the guidance notes off the notices have basically gone online. And the notices now have a web link to Shelter's website and to the government's own possession website, which is being quite regularly updated at the moment as things change. And there is a completely optional set of guidance notes you're allowed to give with the Section 8 or 21 notes, which are the official, which are basically old notes in a different document, but you're under no obligation to give those out. It's up to you. I suppose the interesting thing about this is the use of online tools. The government's very committed, as we all know, and MHCLG has always been quite keen about moving stuff online. I think the difficulty with this is it's all very well if you're talking about tenants in London or cities. It's a more complex question if you're talking about more marginalised and vulnerable tenants and tenants in rural locations. Is it reasonable or fair to say that they have to get all their information off the internet, especially when you bear in mind that there's a dearth of housing advisors in rural locations, and we talk about housing advice desert in the legal sector because there isn't any available, because most CABs have lost their housing advisors and housing advice services have shut, especially during the pandemic with drawdowns in funding. So there's some question as to whether the government's actually doing the right thing. And I appreciate some landlords will say, well, we don't give tenants guidance, that just tells them how to dispute these notices. But in practice, my experience is that if you tell people that they can dispute things and how to do so properly, they tend to do it at the start, and then they get told the truth, which is mostly that they don't have a case. If you don't, what tends to happen is where they're due to be evicted, they start making very late in the day applications to suspend warrants, which are time-consuming and expensive all round, and tend to lead to planned evictions getting blown off for random periods of time, which is less productive. And then you've also got to have a degree of fairness about it. This is somebody's home, and I'm not convinced that the MHCLG's decision to stick all this stuff online in what is, to be entirely fair, not always the world's best guidance provided by the government. It's not. I mean, the flip of that is that the guidance notes of the previous documents were terrible, and it was an exercise in grammatical construction to understand them at all, even for lawyers.
Okay. So one of the themes, I'm not sure whether it's still there, is about digital equivalent. So what you can do online, you can do offline. But that is, I think, presupposes that housing services are available nationally, which they just aren't. I just want to pick up on some of the questions that have come through as we've been speaking. So the first is around the ECL. Just a clarification that it's £10 million gross revenue rather than £10 million net revenue or profit that is the appropriate threshold. Is that correct?
Yes, it's gross revenue, not your profit after tax or anything like that. And it's gross UK revenue. If your revenue is derived partly UK and partly abroad, then it is a fair proportion of your calculated UK revenue. Obviously, the there's just a huge area for lawyers and accountants to get involved in there as we argue about what the fair proportion
Well,
of
hopefully
revenue will
for
be.
most, if not all, of the people on the webinar today, this will be relatively straightforward. But if
Yeah,
not,
I think a lot of people on the webinar today will find themselves below the threshold
yeah.
because it is fairly high.
Follow
But
up on the possession claims, which is, could you please signpost where the new Section 21 and Section 8 notices are available?
well, it's on the Gov UK website. To be honest, I usually just Google search for Section 8 notice, but yeah, 1 second, I will Google search it as we speak and find it. There is a page called Evicting Tenants, so gov.uk/evicting-tenants /section-21-and-section-8-notices.
We'll see if we can put a link in the follow-up email, if that's if
I will place that link because I can answer the question, can't I? Yeah. That would be a sensible thing to do.
Hopefully that is useful.
And dump a link there. There you go. There's a written answer to that question.
Amazing. Thank you. And before we move on to the next section of case updates, just that there have been various changes in Wales around taxes and restrictions. Could we just hear your thoughts on what has changed and is changing that is of note?
In terms of tax?
So council tax on second homes, as an example.
Yeah. So obviously Wales has some, and this is a Welsh only thing, Wales has some devolved property taxation. And specifically the two areas that are entirely within the Welsh Government's competency are the way council tax is done. Obviously it's then devolved down to local authorities, but the overall shape of it is a Welsh Government thing. And then SDLT does not exist. Stamp duty land tax doesn't exist in Wales. It has land transaction tax. So, for example, in Wales, the SDLT threshold was reduced during COVID up till June, and Wales did the same. And then in England, it was the reduction continued through to the end of September. Wales didn't do that. So they had no extra reduction for that period of time. But at the same time, the SDLT, the land transaction tax threshold in Wales is slightly higher. So the amount of property you can buy without paying at all is slightly higher in Wales than it is in England. The Welsh Government has a really good page on this. Actually, they just produced a new guidance note called Differences Between Welsh Land Transaction Tax and English SDLT, which I in no way read before this session. The other thing that the Welsh Government is quite interested in is they've got a bit of a bee in their bonnet about second home ownership in Wales. They have the same 3% uplift as England does, although they apply it actually in slightly wider categories of case than England does. But they're also trying to find, and they've basically said they're going to find ways to make second home ownership more expensive and tougher in Wales, whether it's a second home as your personal holiday home or a second home rented specifically, not so much as rented, but rented on the holiday homes, in the holiday homes sector, as opposed to the standard let sector. And they're mooting 2 or 3 different ideas. The first that's come to consultation is council tax. Now, it's been the case for quite some time in Wales that you can charge council tax uplift on empty properties and on properties that are rented in the holiday sector. Now, nobody charges more than 100% of council tax. So obviously an empty property, normally, a lot of people just don't charge council tax, but you can charge the full council tax rate for an empty property in Wales. Almost nobody does this. In fact, most people top out at around 50%. The Welsh Government is talking about allowing local authorities to charge over 100%, so up to 150% of council tax on empty properties, and on holiday let properties. And they're talking about getting rid of the ability to have holiday lets run as business rates as well. So instead of having the business rateable version, they're going to get rid of that and put them into the full the standard council tax regime. But they're also trying to understand why local authorities don't charge what they can. So local authorities don't charge what they can charge already. The Welsh government is saying, we want you to charge more, but we want to understand why you don't charge what you could charge as it is. So it's a bit of an irony here that the government, the local authority has been complaining about this stuff and saying we want to do more, but they could actually be doing more already. The Welsh government wants to give them more powers to do something they're not already doing, and is trying to work out why. The other two things it's looking at is one is having some kind of licensing regime for holiday lets. Currently, Red Spot Wales doesn't actually cover the holiday let sector. They want that to change. That would be a pretty easy thing to do if you think about it, because the registration structure's there already. They just need to extend it. So they're looking at that. And then they're looking at further alterations to land transaction tax as well to make it more expensive to buy these properties. And finally, they're considering planning, which is something that was mooted in London for quite some time, actually, although it was mostly targeted at empty homes and having planning restrictions that allow you to leave homes empty. And in fact, is a perverse reversal of a planning restriction you commonly find in Wales. So it is not at all uncommon to find in Wales, particularly, two types of planning restriction. One that requires it can only be used for agricultural workers, but also you commonly find a planning restriction in Wales that property can only be used for holiday purposes, and only for a certain number of days per annum, because properties were built for that purpose. And Wales, in effect, wants to overturn and reverse that planning restriction, and have a new type of planning restriction, which has not really been done for. It says properties cannot be used for holiday purposes and have to be used for standard dwelling.
Thank you very much. We are now going to move on to case updates. And I know that various questions will be coming in. We'll come back to them. If you have any questions, comments, insights, please do put them in via the Q&A panel. So first case, what happened in the case of Rakusen versus Jepson?
So Rakusen and Jepson has been ongoing for a while, and basically it came down to this issue of rent repayment orders. So that's where you don't have an HMO or selective license. Your tenants, or indeed the local authority, can go after their landlord. In England, I hasten to add, in Wales they can do it, but it's more complicated. But in England, they can do so directly without any prosecution or anything like that. In Wales, a prosecution is generally required first. They can go directly after their landlord to get their money back, and they can. And it's been quite a big thing in England because, one, a number of organisations have sprung up helping tenants do this, and they've had quite a lot of growth. And then there had been a position where the upper tribunal had gone down the road of suggesting that tenants were, as a matter of default, entitled to all of their rent back for a whole 12 months. Now, in fact, in a very recent decision just last week, they've somewhat pulled this back. But it's notable that prior to the upper tribunal getting involved, the first tier tribunal was giving tenants about 50% of their rent. They then jumped to 100% after the first set of UG cases. It's now dropping back to around 75 to 80% of the rent for 12 months. So it's still a lot.
Yeah.
And it's ended up higher than it was before. So this is quite an increasing thing. The big issue was particularly in the rent-to-rent sector. So if I'm a landlord and I rent my property to a rent-to-renter, it remains the case that quite a lot of these guys aren't terribly good and frequently don't bother with such niceties as HMO licensing. And some top-end landlords don't realise that they need them because they don't realise it's still their responsibility. So you're subject to prosecution or a civil penalty from the local authority. The key question is whether your tenants were entitled to go after you as the top level landlord, or whether they could only go after their immediate landlord, the rent-to-renter. So there was, from a tenant's perspective, going after a rent-to-renter was often a waste of time in respect of a rent repayment order, because the rent-to-renter didn't have any money, was frequently a straw man, and would simply disappear. And if it was a limited company, it would have no assets and would just fold up rather than pay you. So what this means is that tenants were trying to go after the landlord above that in the whole sequence, and the upper tribunal had allowed them to do this, and it went to the Court of Appeal, who said no, you can't do that. Is the short position. So the Court of Appeal's position is no, you can only go after your immediate landlord. Now, what of course this also does is open up a bit of a loophole. So if you're an HMO landlord and you want to cut down on the risk rent repayment orders, you can create a limited company, rent your property to the limited company, and then have the limited company be the people who actually rents onward to the end tenants. I mean, this also has potential tax benefits, but I'm not an accountant, so take your own tax advice. But this opens up a somewhat unintended loophole that you could arrange things such that there was a limited company always sitting between you and your HMO tenants or your licensable tenants, so that in practice it was never possible for them to pursue an effective rent repayment order.
So sets up a special purpose vehicle per property, isolate the risk, assuming there were no challenges there for the mortgage, assuming that there was lending against the property. That is a huge loophole.
Yeah, I mean, it wasn't an intentional. I mean, you can analyze this two ways. I mean, one, a rent repayment order is a substantial penalty.
Yeah.
And so landlords who are relatively innocent and have rented in good faith to a renter shouldn't necessarily be stuck with that liability. And Parliament didn't write the law that way. It's actually quite clear how Parliament wrote the law. It's pretty, the upper tribunal developed a fairly hokey construction to allow this to happen, which the Court of Appeal wasn't having. But an unfortunate side effect of this is that, one, tenants don't get anything from dodgy rent to rent, and one of the arguments that was being pursued in the Court of Appeal by interveners was that this should continue because landlords should be motivated to rub out bad rent to rent by not renting to these people. And to be fair, I think landlords shouldn't rent to these people, so I can see the argument there. And of course, the side effect of this is it's opened up this somewhat unintended loophole that means that landlords are potentially motivated to place intermediate companies in the way. I mean, the flip side of that argument is, to be fair, there's always been good reasons to put an intermediate company between you and your tenants, actually, for lots of other reasons as well. Mm-hmm. Long before rent to rent ever appeared. I mean, it has value. If you're trying to limit your liabilities, obviously having a limited liability company limits liability. That's what it's for.
Yeah.
And so it's had value in lots of other legislation as well, although some of those loopholes have been closed over time. So, you know, it's not necessarily a new trick. And of course, it doesn't protect you from prosecution or a civil penalty, because you can go after the directors of a company for that.
Yep.
You would have to do something really hokey involving overseas companies and nominee directors to escape that.
And I think we should stay away from that on today.
Yeah, I will avoid providing questionable immoral advice.
And so, just for anybody who wants to look up the case, it's Rakusen, Rakusen, and Jepsen, Jepsen. And David, have you written an article on that?
I have, and unfortunately, I mentioned this loophole and have been roundly criticised for telling people about the loophole.
And we will move on then. We've got quite a lot of other topics. It looks like various questions have come in. What can we learn from the recent High Court case relating to breathing space and mental health crisis moratoria?
Yeah, so this is just really, I mean, for lawyers, obviously, it's a really fascinating case because it's the most epically long-running and fairly hardcore piece of mortgage repo case law. It's called Axe, Loller and Break. And if I tell you it's had 2 appeals to the Court of Appeal, there's been attempts to get 2 of the judges to recuse themselves for alleged bias. And there's been, I don't even know how many hearings. There are cost orders totaling millions of pounds already in this case. Never mind the fact that there was money owed in the first place. This is what this was started about. It's a properly bonkers piece of litigation. It's the kind of thing that lawyers go out for strong drinks about and chuckle as they see their bonus packages inflate. But for sane, reasonable thinking people, it's just an example of law having gone a little bit mad on itself. But more to the point, the Breaks are currently litigants in person. They owe quite a lot of money in cost orders, as I intimated. And one of them, 2 days after the breathing spaces came into effect on the 4th of May, so on the 6th of May, he immediately applied for a mental health breathing space, as you do, and was granted it. Now, this, of course, immediately meant the Breaks didn't have to pay the nearly £500,000 of cost orders that they currently owed, because those debts immediately fell within the breathing space moratorium. The claimants, Axnoller, etc., took umbrage, to say the least, and they immediately wrote to the debt advisor who'd given the breathing space moratorium and said, you should withdraw it. They refused, and they applied to court, all within a week. So this litigation commenced literally as breathing spaces. We were just talking about them a little bit, saying, oh, this is there. How interesting. These guys had all gone and done it, like before we'd even finished talking about it. So this then comes before the High Court. The High Court made some general procedural comments, most of which I won't trouble you with. I mean, it was very keen. The High Court was quite keen not to set too much precedent, because they were very conscious it was the first case and was a bit unusual. I think the things that were interesting about it is, one, the High Court said the claimant shouldn't have rushed into the application. They should have actually got some evidence together first, because they were saying that, for example, that the moratorium wasn't applied for in good faith, but they had no evidence of that. It's just that they felt it was crap. So that's not quite the same thing. Because the person who'd applied for it had evidence from a mental health professional that said that they needed a moratorium. At the same time, the evidence of the mental health professional was criticised, because it didn't. The point about breathing space, of course, is not just to let you off your debts. It's to provide you with a breathing space to sort things out, and then hopefully to make debt arrangements. And the evidence from the mental health professional gave no indication of how long the mental health crisis was expected to last, what the prognosis was, whether there was any improvement or any of these things. Now, part of that was due to the unseemly rush, of course, in getting it before the courts, but the court said that would have been helpful, so it's a point to bear in mind. The other part that was really interesting about it is the Breaks were actually trying to argue that a mental health breathing space shouldn't just apply to debts that existed at the time the breathing space was applied for, but that any new debt should also be lumped into the breathing space, and it should continue. And the argument they made in support of that is, if the court didn't find that, then it was perfectly possible for someone in a breathing space to simply ask for it to be ended and then immediately apply for a fresh one, lumping in the new debts. And the court said, well, breathing spaces have to be applied for in good faith. And while the court wasn't prepared to find those findings of bad faith in this case, they made the point that someone who had applied for a breathing space and then immediately ended it only to apply for a new one to wheel some more debt in that they'd acquired during the breathing space would be highly at risk of being accused of doing so in bad faith. So, of course, it drew a distinction between situations where debts came along that were incurred before the breathing space started, which would be brought into the breathing space. They're just things you didn't know about but already existed, and entering to a breathing space and then continuing to accrue debt instead of using the breathing space to start to resolve your debt issues.
And that's particularly interesting for the audience, I think, because unlike other forms of debt, rent typically accumulates on a monthly basis. Could be quarterly, could be annual, but typically on a monthly basis.
So what this tells us, and you know, most of us thought this was the case anyway, but the point about this, and it is in the regulations, is during a breathing space, you must pay your rent.
Yeah.
And what the High Court is pretty clear that you can't do is not pay your rent during a breathing space, then end your breathing space and start a fresh breathing space in order to try and get your new chunk of rent arrears brought within the breathing space.
And so could I just step through this to make sure I've got it clear? So a breathing space is granted. Let's assume it was in good faith. The first month ticks by, rent isn't paid, let's assume, and it carries on. Would the agent or landlord then be in a position to be able to issue a Section 8 notice thereafter?
Yeah. So there's no moratorium in respect of debt that is acquired during the breathing space, only debt that is before the breathing space that's subject to the moratorium. And in theory, a debtor can terminate their breathing space, apply for a fresh one to get that new debt in, but that is a pretty high risk tactic, to say the least. I mean, there may be circumstances where it's appropriate, don't get me wrong, I'm not saying you can never do it, but the High Court was pretty clear that you would have to have some pretty unimpeachable reasons for doing it.
Perfect. Thank you. We're going to move on. We've got two more, I guess, chunky topics, and definitely want to have time for the audience questions. So moving on, Chinese data protection law.
So I don't want to deal with this very quickly because it won't apply to a lot of people, but the Chinese government has passed a data protection law, which comes into force in China on the 1st of November. But just like the GDPR, it has extraterritorial applicability. What this means is that if you process data for Chinese residents, so they have to be residing in China, then you are subject to Chinese data protection law. And the particular thing of concern is that you are required to have a representative in China for data protection purposes. Just as if you want to process EU nationals' data routinely, you must have a representative in other EU countries, as Raj can attest. But the point, I think this is quite a big deal for the UK property sector, is that there is a significant number of Chinese investors in the UK property sector, even though technically they're not really supposed to be investing in Chinese property sector, in the UK property sector, and it is actually unlawful under various bits of Chinese law in most cases for people to do so. It does apply where you're trying to target Chinese nationals, for example, to invest in your development, which many developers do in fact do. And those developers will need to ensure that they have appropriate Chinese reps. I have managed to source this week, last week, an appropriate company to do the representation work, but it wasn't simple because the consequences obviously are significant. You can be fined in China. Individuals can take cases inside China, which they will then seek to enforce outside China. And I have had people saying to me, "Oh, what do I care? It's in China. What are they going to do to me?" But do bear in mind that one, if I take a debt claim against you in China, or I take a case against China and win it, I can then enforce that judgment here. And two, don't think for a moment that you can sit and ignore this and then fly to China to go and see the Great Wall of China and think you'll get to leave the country again. China is perfectly able and perfectly prepared to put markers on people's passports and detain you. So, if you're the director of a company that is willfully ignoring Chinese data protection law, don't just assume that makes it not a problem.
Could I just go through three quick fire questions? Are probably coming in faster than we're speaking at the moment, so it seems like this is of interest. So the representative need not be an employee or a contractor. It could be for example, third-party law firm as a representative, as you would do under GDPR within the European Union. That's correct, isn't it?
Yeah, and indeed, I imagine most people will do that unless they have a very, very large Chinese presence.
Perfect. And so residing in China is an interesting point. So an investor who lives in China would clearly fall within that definition, but a Chinese national who is a student who is applying for a tenancy, for example, before they've started residing in the UK, would be a resident of China and therefore fall within the
Well, I mean, there's an interesting question. I mean, the fact is, it's only where you're processing Chinese nationals, Chinese residents' data for the purpose of selling them services. So if one of them approached you, then it'd be debatable whether you're actually trying to process the data to sell them services at all. And of course, as soon as they left China, they wouldn't be a Chinese resident, so it wouldn't apply. So, there are some grey boundary areas. The problem, of course, with it all being rushed through is there's no guidance available on these kind of questions. Like, I have some difficulty answering them.
I guess the final question before we come on to outsourcing is Chinese resident. Does that extend to Hong Kong, for example?
No, it doesn't apply to the Hong Kong Special Administrative Region. That's a separate legal jurisdiction.
Thank you.
They are passing their own data protection legislation and did, I think, last week, but it's not as comprehensive.
Okay. Outsourcing property management. So lots of questions have been raised by people I speak with across the sector, and I suspect you've been facing the same. And we thought it'd be useful to just sort of I'd describe it slightly more than a primer on outsourcing property management, the things you should consider. There is a lot. And I guess starting at the very top, trying to think the right way of framing this. Does an agent who is outsourcing property management require the consent of their landlord? And if so, does it require informed consent in any particular way?
Right. The common law of agency has always been clear that agents are not permitted to subcontract or assign any of their responsibilities without specific consent, which is why you'll find almost every agency terms of business ever has a clause in it that says we can assign or subcontract any of our responsibilities to a third party. Um, does that consent need to be informed? Probably not, because it's not. It would be different if there was a profit being made. So if there was a commission involved, then yes, it would need to be informed.
Yeah.
And this is a point I have talked about a number of times. And I would say that a lot of agents simply are not doing the right thing on commission.
Mm-hmm.
And we've talked about this before. Um, but no, I don't see any reason why you need to be very specific about where you're outsourcing or subcontracting your responsibilities to.
And just sort of following on from that, is there anything that's required in respect of GDPR by using the outsourcer as a sub-processor?
Well, yeah, absolutely. I mean, if you're a data processor, then a standard feature of the GDPR is that you can't use sub-processor without consent. So you would need to have that baked into your data controller processor agreement. And of course, if you're transferring people's data to third parties, then your privacy notice should reflect the fact that their data is going somewhere else and being processed by somebody else, and so privacy notices will need to reflect that. But that's not a contractual aspect.
I saw an article today talking about CMP. So I guess just again, the very sort of general lob question to you is, what should agents be thinking about in respect of client money protection if they are outsourcing or thinking of outsourcing property management?
Well, this is really just a really interesting. I mean, as this article I saw today it said, and we've talked about before, so I wasn't surprised to see it. There is a major loophole in the CMP regs. The CMP regs say you have to have CMP if you're carrying out, if you hold client money and you carry out letting activity. Now, the interesting question here is, what if you don't hold client money and do letting activity? Or even better, if you don't hold client money and even don't do the activity. So there has always been a position that there was scope for outsourced client money protection regimes, and these exist in other places. They exist for solicitors, so small firms of solicitors, particularly, who have relatively limited needs to hold client money, are able to outsource their requirements to organizations. There's one called Shield Pay, but there are others. And barristers have done it as well through something called Barmark to allow them to take direct access clients. So you can outsource your obligations, which means you don't have to go through all the auditing and insurance stuff normally associated with client money, and a third party handles it for you. In principle, there's no reason why agents can't do the same thing. Now, what was interesting about it is some organizations like Property Mark, for example, jumped on this and said, oh, hang on a minute. If you want to join our CMP scheme, then either you hold the money yourself or you use one of the approved outsourcing. You can't just outsource to anybody. So Property Mark has approved, I think, one or two organizations for that purpose. But this has become a really big issue because the regulations also say you have to use a bank or building society. So they don't allow you to use things like a money provider. So some of the new style banking arrangements like Revolut, which aren't actually properly accredited banks or banking building societies, they're money service providers, but still pretty heavily regulated and protected. You can't use them. And a lot of banks are being very difficult increasingly because of choosing to interpret money laundering regulations about whether they'll accept agents' accounts at all. I'm aware there's a large number of agents who effectively can't operate pooled client accounts.
Yep.
And banks are either saying that they don't want the business or making them open one bank account per person in the way you might do if you're doing, which is not uncommon if you do block management, for example. Yep. But then, of course, you'll have far fewer clients. So it makes a lot more sense. And the amounts of money are usually much greater as well, of course, so it all sort of works better. But a number of banks are being very difficult about pooled client accounts for letting agents, and I'm actually aware HMRC are very frustrated about this because HMRC are aware that a large number of letting agents have applied for regulation as if they were regulated by the 5th Money Laundering Directive, even though they're not. Partly at the behest of banks who are hassling them about their pooled client accounts and suggesting if they apply for HMRC money laundering regulation, that will be okay. And HMRC is has been on to UK Finance about this and is trying to get them to talk to banks to calm themselves down. But they're also starting to look through their list of letting agents with the intention of one, not taking money off people who don't need to regulate, but also booting people out.
Yep.
Who don't need to be there, because obviously it's a waste of agents' money, but it's also a substantial burden on HMRC to deal with regulation and auditing of people who don't actually have any Fifth Money Laundering Directive tenancies at all.
Sort of dialing it back to the outsourced property management piece, because I think we've got a few questions coming in. The upshot is there is a gap in the CMP. What happens in respect of tenant deposits? So who retains the liability for registering the deposits if, for example, the letting is carried out by an agency and the deposit registration ought to be carried out by under their agreement or service level by service agreement by the outsourced provider? If it wasn't so registered, who has the liability?
Well, the way the law is constructed, it'll be all the way down the chain. So the landlord is liable, but so is anyone acting on the landlord's behalf. So the landlord and his first-tier agent would be liable, and so would the outsourced property manager. But if the outsourced property manager has gone, shall we say, and is clearly not a viable defendant in a claim, then it's going to come back to the landlord and the agent. And of course, the landlord would, even if it's the landlord that you claim against, the landlord will have an immediate claim against the agent. Because the agent subcontracted those responsibilities. So the difficulty about this is obviously it's getting a lot of press at the moment, but there's no real magic to this. Outsourcing has been a common feature across a range of different businesses for a long time. The reason it's been a problem here is that agents, one, haven't had suitably robust contractual arrangements. Two, they haven't thought carefully enough, perhaps, about who it was who was actually outsourcing, in the assumption, perhaps, that one of the various schemes out there would rescue them if it all went wrong. And three, it remains the case that some agents are just a bit too casual with other people's money. Not to put too fine a point on it. It ain't your cash.
Thank you very much. And I'm going to hand over or move over to the questions, the audience questions. So we picked up quite a few as we've gone. We're starting with a comment, which is from someone in the audience basically saying, does the government and housing support groups realise that the hostile anti-landlord approach is hugely impacting supply and consequently will cause bigger problems for housing supply in the PRS? I'm not asking for a response to that, David, but
I think the short answer is not really, no.
Sorry. We had lots of questions about Section 21 and Section 8. Just as a reminder, we have a combined, I believe, fact sheet from JMW and Fixflo, which will be in the follow-up email that you receive. So the latest Section 21 and Section 8 rules. And David, a question specifically to you. You say there is no obligation to provide the guidance notes. Sorry, I need to put my teeth in. Would you recommend, however, that you would provide them as best practice? Is it best practice to provide the guidance notes in the absence of a requirement to do so?
It certainly wouldn't do any harm to do so. So yes, I mean, if you, I suppose I would say it depends on your tenants. If I was dealing with large numbers of vulnerable tenants with limited access to the internet, then the answer is yeah, I would tend to provide them. If I wasn't, I was doing all students, then I probably wouldn't.
Some interesting comments, I would say, rather than questions on the ECL. In Southwark, they charge 100% council tax for empty properties, and in Manchester and Stockport, it tiers up based on the length of vacancy. It's probably the right way of putting it, of the property, all the way up to 300%. So on the ground info there from the audience.
Right. Yeah, England has more power on empty property. I mean, I think what Wales is perhaps more interesting in relation to is perhaps what they're trying to do with holiday homes, which is different.
So just pausing there on the holiday home. So you described a sort of what I describe as a reversal of the planning requirements, which previously said this can only be used for a holiday home to this cannot be used for a holiday home. Does that mean that those that have being used for holiday homes for long enough will de facto have those rights and therefore become more valuable in the market?
Possibly, it really depends on the way that I mean, you have to wait to see from the consultation, frankly, what the Welsh government goes with. I mean, it's a bit of a difficult one because some of these powers exist and they're just not being taken up. So one of the arguments is, why on earth would you increase it when people don't use it anyway?
Well, and actually, that's one of the most common arguments I hear against sort of overarching or new forms of regulation across the private renter sector. The regulations and the enforcement provisions are already there, they're just not being used effectively. And what we need is better and more consistent enforcement and education of for both landlords and tenants of their rights and obligations, rather than an addition to the patchwork quilt of rules. Although perhaps the counter argument is typically that a single set of rules, to the extent you can get there, makes it easier for people to understand. Rent to rent. Sorry, do we have to check visas as they expire?
I've just typed an answer to that, but
okay,
the short answer is that right to rent checks have to be done for time limited checks 12 months, or when the time limited right ends, whichever is the longer. So it will depend on how much is left on your visa and what the visa period was. If it was less than 12 months, then you don't have to check it when it expires. You don't have to do the check for 12 months.
And a note from my colleague Remy, who organises this entire production, that she's going to include a section, a right to rent flowchart, get the right thing, in the follow-up email for everybody. So all of the information around that will be included.
I think we did an updated right to rent guidance document.
We did collectively with David Smith of JMW Solicitors and Fixflo, and that will be included in the follow-up email to everyone who's watched today's webinar. I'd really be very grateful if everyone who is on today's webinar could take a moment at the end to provide us with some feedback. We need to know whether we're covering topics that are of interest to you, and if we're not, which ones would be. Are we covering them in the right level of depth? We want to make this as useful as possible to you as we start to build out the plan for the quarterly legal and compliance updates through next year. So if you could please just take a couple of seconds at the end, we'd be really grateful. And with that, you can check out live and on-demand webinars via the Fixflo website. And if you'd like to know about things we've got coming up, please follow us on all good social media channels. Let us know via the feedback form at the end or via an email to research@fixflo.com what your thoughts are. Thank you all so much for attending. And thank you very much, David, for sharing your wisdom and insights with us and putting up with my lines of questioning through today. Hopefully it was useful to everybody.
Brilliant. Thank you very much.
Thanks. Bye.